Ladies and gentlemen, welcome to this seminar on recent case law on defining a project and its effects, brought to you by Pinsent Masons, Mott MacDonald and Landmark Chambers. Firstly, can I begin by apologising to everybody for the late start of this. We've had technical problems, as a result of which, rather than working off a central system, each of the speakers is now going to be working off their own laptops and working through the speakers on their laptops. I think, does the speaker probably, no, okay, sorry, we're still sorting out the technical problems, as you can work out. Anyway, we are delighted to see as many of you as there are still with us today. We have over 450 people signed up, which is a reflection of the importance of the topic. We hope that you will find the presentations and indeed the discussion which happens afterwards, in which I hope you'll all take part, useful and informative. My name is Paul Brown. I'm a barrister at Landmark Chambers. I'm going to be your chair for this event, and because I can't use this because of technical problems, I'm going to have to use my best Chris Whitty voice and say, next slide, please. I'm going to be, as I say, chairing this event with my colleagues, Matthew Fraser, Nick McDonald, Stephanie Brown, and I'll introduce them a little more formally shortly. To begin with, a few housekeeping points to note. Firstly, your microphones are all muted, so you don't need to adjust your own local settings. Secondly, the webinar is being recorded. You'll receive a link to the presentation and the recording shortly after the event concludes. And lastly, at the moment, if your connection is lost at any point during the webinar, you should be able to rejoin by clicking on the original link once again. Turning to the structure for the webinar this morning, if I can have again the next slide, please, or one that pulls up the list of speakers. First up, I'm going to start by setting the scenes with some general observations on why this topic is important. My own interest in this area flows mainly from the fact that over the last 5 or so years, I've been working quite closely with a number of campaign groups like Friends of the Earth, Client Earth, who've been leading the way, really, in trying to force the applications for fossil fuel extraction to include impacts on climate change in their environmental impact assessments. And so, for example, in 2018, I was at the Druridge Bay coal mine inquiry. That was an inquiry about thermal coal. Last year, I was at the West Cumbria coal mine inquiry, metallurgical coal, but in both cases, the downstream emissions of burning the coal was extracted very much in play. And of particular relevance for the purposes of today's seminar, I represented Friends of the Earth in the recent Finch litigation in the Court of Appeal, where we were an interested party, albeit one who was only allowed to make written representations at that stage. So that's me. After that, Matthew Fraser is going to delve a little bit more deeply into the recent case law. He's going to talk you through exactly what Finch has and has not decided, and also look at some of the other cases around the area, such as Greenpeace. Like me, Matt's a barrister at Landmark Chambers. He's got considerable experience of dealing with EIA matters. He appeared in the Supreme Court in the Kent and Dover District Council litigation, which was about the duty to give reasons for granting permission for EIA development. But also, like me, he's been involved in the Finch litigation. He's on the other side of the fence with David Elvin, where he was instructed by Horse Hill Developments. Because that litigation is still ongoing, there's an application for permission to the Supreme Court. He and I probably need to be a little bit careful about what we say about it, but I hope nonetheless, between the two of us, you'll get both sides of the coin. As Matt will explain to you, Finch is a case concerned with deciding what are the effects of a project. And one of the points that will emerge from that is the importance of deciding exactly what the project is. And that theme is going to be taken up by Nick McDonald in our third presentation this morning. Nick is a partner at Pinsent Masons Planning, Energy and Infrastructure team, advises on a range of infrastructure and development schemes, particularly nationally significant infrastructure projects, and those relating to the energy transition, power and industrial carbon capture storage, hydrogen projects, as well as major estate regeneration and CPO. And then to follow that, because ultimately what many of you want is not just a legal analysis but some practical guidance. Stephanie Baldwin is going to wrap up by talking about some of the practical ways in which decision makers, like local planning authorities, can go about making a decision, and also ways in which applicants can help those authorities to come to the right decisions and to approach the judgments that they've got to make. Stephanie is a technical director with Mott MacDonald, a chartered environmental professional. She's been in the business for over 28 years across a wide range of sectors. And in that context, she's been involved in the management, the scoping, the preparation and delivery of environmental impact assessment for projects for a variety of planning consent regimes. Usefully, I think, in terms of a sort of comparative understanding, not just in this country, but also in Cyprus, the United States, Turkey, Australia, the Middle East, Singapore, and Hong Kong. One of the things that was interesting about the Finch litigation is the extent to which, even in the Court of Appeal, there was authority cited from different jurisdictions about the extent to which it's even possible to carry out the sort of assessments that we're going to be looking at. At that stage, we're going to open the floor to questions from you. Most of you, I hope, will be familiar with Zoom. You can submit questions by text in the Q&A session, and you should be able to find that at the top or the bottom of your screen on one of the little toolbars. If you want to remain anonymous when you ask a question, please make sure you tick the send anonymously box. We will do our very best to deal with all your questions, and if we don't manage to, apologies for that. Although we will try and deal with them all at the end of the 4 presentations rather than as we go, don't let that stop you from sending off questions as and when they come to mind. Once my presentation is over, I shall be sitting in front of my laptop trying to organise the questions into a sort of coherent structure and order. So obviously, the sooner you can get questions up on the screen, the easier it will be to do that, and hopefully the more effective that discussion will be. Okay, that's everything that I wanted to say by way of introduction. I turn then to the first of the presentations. Why does any of this matter? As if you need persuading since you're already here. I'm going to start with a little audience participation with a short poll. It has 2 simple questions which should appear on your screens shortly with a simple yes or no vote. Yeah, the first question is, do you think the climate change implications of burning fossil fuels should be taken into account when granting permission for the extraction of those fuels? And we've got answers coming in. I'm going to end the poll fairly shortly. All right, I'm going to call an end to it there. And we've got what is a fairly overwhelming 84% who think that they should be taken into account at the point of deciding whether to grant permission for extraction. The second question is different, although some of you may wonder whether the difference is important. The second question I'd like you to answer is this. Do you think those climate change implications should be set out and assessed in the environmental statement for those schemes? Question 1, are there relevant considerations? Should they be taken into account? Question 2, should they be in the environmental statement? Okay, that's interesting. Yes, on that, I don't know whether the answers to the second one were influenced by the first, but the result of that is 95% of you think, or sorry, 81% of you think that that they should be in the environmental statement. Okay, so next slide, please, if we can. Why does any of this matter? The answer, I think, depends very much on who you are and the perspective from which you are asking the question. Starting, first of all, from the perspective of applicants and decision makers, the reason probably why it matters most of all is because over the years, the requirements of environmental impact assessment have been a happy hunting ground, really, for local residents and campaign groups seeking to challenge the grant of planning permission. And one of the reasons why that has been the case is because although in a lot of areas of planning law, the ultimate decisions turn on matters of fact and degree, where the courts are really reluctant to intervene with what decision makers decide. In the area of EIA, lawyers have found it much easier to find hard-edged questions of law around the EIA regulations. So, just by way of example, many of you will be familiar with at least the general principle that you can't avoid the requirements of EIA by salami slicing a project into a series of smaller projects, each of which falls beneath the threshold for assessment. And what is important about that is that there are a number of cases, next slide please, where the courts have been willing to effectively grapple with the question, what is the project themselves? So I've put some examples on the slide. First of all, Borage and Breckland. That's a case where the Court of Appeal held that applications for biomass renewable energy plant, combined heat and power plant connected by an underground gas pipe, that they should have been treated as a single project. Larkfleet was a case where you had a link road on the one hand with an urban extension project on the other. Those were treated as two separate projects. The Court of Appeal said that that was appropriate in that case. Now, although you get opposite decisions reached as to whether or not there's a single project, what for me is significant about this is that on both occasions, the court was looking at that question as if it was something for the court itself to decide. And in that regard, in the third case on the screen, Bowen West, Lord Justice Laws drew a distinction between screening cases and scoping cases. And in the case of screening cases, he said the courts have been concerned energetically to put a stop to the device of using piecemeal applications as a means of excluding larger developments from the discipline of EIA. Scoping decisions, on the other hand, you've decided that something is EIA development, and the question is what needs to go into the environmental statement. That has generally been a more difficult area for challengers to get traction, because generally speaking, the adequacy of an environmental statement has been a matter for the decision maker. But even there, it's an area where the definition of the project matters, because if you get the project wrong, you may not avoid the need to prepare an environmental statement. It may still be over the thresholds for EIA. But if you're only looking at a smaller part of the overall project, then it may well be, it's likely to be, that you won't actually have assessed the full effects, and that itself is a problem. I think the second reason why, certainly historically, EIA has been such a happy hunting ground for objectors is that until a few years ago, breach of the technical requirements of the regulations was seen as almost invariably fatal, with very, very little room to argue that relief should be refused in the exercise of the court's discretion. Now, the high water mark of that is almost certainly the judgment of the House of Lords in Berkeley No. 1, where, as some of you may remember, Lord Hoffman emphatically rejected the idea that the court could retrospectively dispense with the need for EIA on the ground that the decision maker had all the necessary information in front of them, and even if it wasn't in an environmental statement, they took it into account, and so the decision would inevitably have been the same. Now, I think it's fair to say that both of those features, the hard-edged question of law and also the reluctance to exercise discretion, they've become a lot less pronounced in recent years. Certainly in terms of discretion, cases like Walton and Champion have shown a much, much greater willingness to refuse relief in the exercise of discretion. And there's also a growing body of cases which suggests that even the decision whether something is a single project is, in the first instance at least, a matter for the decision maker. And so, for example, in Wingfield, Mrs. Justice Lang rejected a challenge to a conclusion that a proposal for a development of 370 houses on one side of the road and 250 homes on an adjacent site, rejected a challenge to the conclusion that those were separate developments, and she said quite clearly that what constituted a project was a matter of judgment for the competent authority. I think it's relevant in that case that both of those schemes were individually the subject of EIA, And so there wasn't a question of totally avoiding the assessment process. One of the key cases that we're going to look at today, Finch, is actually an example of that same trend away from classifying things as hard-edged questions of law, as Matt Fraser is going to outline for you shortly. At first instance, the challenge to the decision there was rejected on the basis that downstream emissions of greenhouse gases were incapable as a matter of law of being an effect to be taken into account. The Court of Appeal has moved away from that and put it much more into the realms of planning judgment. But despite that trend, it demonstrates, Finch I think still demonstrates, that EIA is a continuing ground for challenge. Even if those challenges ultimately fail, the mere delay that is involved, the time that it takes to get a case to the Court of Appeal, can be extremely damaging and extremely costly for applicants and for anyone else involved. And also, for that reason really, for developers in particular, it makes good sense to get the decisions about whether you need to undertake EIA at all, and the decisions about what you need to assess, to get those right in the first place. Indeed, it may even be said that there are good reasons for putting in something, even if you think technically you're not required to do it. I know at the Druridge Bay coal mine inquiry that I referred to earlier, the developer effectively put all that information on the table as part of the evidence at the inquiry, without prejudice to the argument that it didn't have to be there in the environmental statement. And that's something that I think Stephanie might be able to talk a little bit about later on. But that leads me really to one of the other reasons why cases such as Finch are important, because if we are in a world where we've moved away from what is the project, what are the effects, being a hard-edged question of law, then you need to know how to go about making that assessment. And one of the things that the speakers who follow me are going to deal with is to what extent are there guidelines that it can help you, either as a decision maker or as an applicant or even as a potential challenger, to work out what needs to be assessed and what should be done. I don't want to trespass too much on that territory myself, but there are two things that I think are worth mentioning. The first is that in the past, a lot of developers have used the argument that it's difficult or it's impossible to produce a meaningful assessment as a reason for not doing an assessment at all. Now, that's something that I think Stephanie is going to comment on in her paper, at least to outline what can and can't be done. But it's certainly in the context of Finch, as Matt will explain to you, that's an argument that's become much more difficult in the light of the Court of Appeal's decision. It seems to me that's entirely right. Obviously, there's a point at which an environmental impact assessment or a statement is so vague that it really doesn't serve much useful purpose. But generally speaking, it's possible to express likely impacts within a range. You can certainly come up with a worst case scenario. And that is certainly true of climate change, where the basic equation, how much carbon dioxide do you get when you burn coal, oil, gas, is fairly straightforward chemistry. There are complicated arguments about how much of it ends up in the atmosphere if you've got carbon capture, but the basic number crunching is something that's perfectly possible to do. The second notable feature of the case law is the way in which cases like Finch demonstrate that this isn't just about defining the project, it's also about deciding which effects you can properly attribute to the project. But, and this is where it gets a little bit tricky, one of the things that you'll see about Finch, and the other speakers will explore, is that theoretically neat dividing line between project and effects isn't always as clear-cut as you might like it to be. So turning away from applicants and planning authorities from the point of view of campaign groups, why is it important? The question is important not just because people are looking for grounds of challenge, but mainly because they genuinely want to make sure that the effects of development are properly understood. And in part, that will be to make sure these things are taken into account in decision making, In part, it's also sometimes part of a wider campaign to promote greater awareness of the issues. And that certainly has been the case in the context of the fight against climate change, where there's a growing frustration at the mismatch between the rhetoric of government on the international stage, platforms such as COP26, and the decisions that are being made on the ground, which keep perpetuating a system which is dependent on fossil fuels. One of the major problems here in the context of the IEA is that the activity which actually results in the emission of greenhouse gases is frequently not the subject of planning control, and it's not actually a part of the application for permission for extraction. Although there will be a level of CO2 emissions associated with digging coal out of the ground or drilling for oil, that's usually a tiny fraction of what will happen when the fossil fuel is actually burned. And the point here is that the gas that comes out of the North Sea doesn't become a greenhouse gas until it's burnt on the cookers of homes around the country or in the boilers of people's homes. Similarly, the oil that comes out of the ground from the North Sea or out at Horse Hill won't become carbon dioxide until it's refined into petrol, and somebody then drives to work and uses it in that way. But the argument of the campaign groups on that issue has always been really twofold. Firstly, although mere extraction of a fossil fuel doesn't involve combustion, the eventual combustion is really pretty well the only reason why anybody bothers digging the stuff out of the ground in the first place. It's not only a foreseeable consequence of extraction, it is in many cases inevitable. And the argument is, well, if that's the case, it should be assessed. I think the second point is that it's often the only way of making sure that the impact of fossil fuels on climate change is assessed. If you don't do it at the point of extraction, there will often be nowhere else where that is taken into account. So from a campaigning perspective, it's extremely important that the project and its effects are defined, if I say properly, the campaign groups would say, so as to include these further downstream emissions. Now, that's an argument for which the fossil fuel industry has resisted for a very, very long time. It's gone about it in a number of different ways. In the past, a lot of those have been essentially fact-based, the argument being, well, there won't be an effect, essentially because if you dig coal out of the ground in Northumberland and use it to fuel coal-fired power stations in the UK, that's not adding to greenhouse gas emissions. Those power stations would be burning coal anyway. It's just that they would import it from Australia or America or Russia. And if they did that, then you'd have to transport it halfway around the world, so isn't it better? And that's an argument based on the assumption that there is pure substitution. You can have your own views about that, about the way in which it fits with fairly sort of basic economic theory, but that's been a fact-based argument which simply says there will be. What is, I think, interesting and important about the recent case law is that it moves away from that question of whether in fact you're going to make metals worth to the question, is this even an effect of the development? Is it an effect of the project? And that is an argument which, for me, gives rise to what is, I think, intellectually one of the most interesting things here, but also for the campaign groups, one of the most problematic things. If you stand back from the detail, it's possible to look at cases like Finch and say, well, obviously it matters to work out what goes in the environmental statement, but that's all that Finch is about. And the fact that it isn't in the environmental statement doesn't mean it's not a relevant consideration. And I think probably as planning lawyers, most of us would look at that and say, well, of course that's right. If you think about it, most planning applications don't even have an environmental statement, but they're still granted or refused on the basis of impact. So it must be possible to have an impact, which is a material consideration, even though it's not in an environmental statement. The difficulty with that is it overlooks the point that the reason why in most cases you don't assess those impacts is because of the scale. We all know EIA only kicks in when certain thresholds are reached, and most things simply aren't big enough. That doesn't mean that the impacts aren't material considerations. But what I think is important about Finch is that that's not the basis on which it was held you don't need EIA. Finch holds, these things aren't an effect, not even an indirect effect of the extraction itself. And this is one of the reasons why I put the poll up to start with. I'd like you just to think about that for a moment, because it seems to me that it opens the way to this question. If something isn't even an indirect effect of development, how can it possibly be a material consideration in determining the application for that development? And that certainly is the way in which Finch is already being used by developers. At West Cumbria inquiry, for example, the applicant argued that the impact of their coal on climate change was legally irrelevant because at that stage the High Court had concluded it wasn't even an indirect effect of extraction. Now, I should make it clear that I personally don't for one moment believe that that's what either the High Court or the Court of Appeal was saying. I'm personally fairly sure that they were saying the complete opposite. But you can understand how the argument is built, and that is a cause of real concern to campaign groups, because if that argument gains traction, it will make it impossible to use climate change as a reason for objecting to fossil fuel extraction. And in that context, over 80% of you, when I asked the question to start with, thought that it should be a relevant consideration at least. I'm going to leave things there. I'm going to pass over now to Matt, who can put some more flesh on the bones of what I've been talking about, take you into Finch and some of the other case law and explain exactly what it is that that case decided. Thank you very much.
Good morning, everybody. So my talk's going to zoom in a bit more on the Finch case, which is, as Paul mentioned, both he and I were involved in, and also look at some of the other case law on indirect effects. Can I start with the next slide, please? So I thought it'd be useful just to return to what the EIA regulations require. And the first thing is that the EIA must identify, describe, and assess in an appropriate manner, in light of each individual case, the direct and indirect significant effects of the proposed development on, and then a series of factors. And then further, that the description of the likely significant effects on the factors specified in Regulation 4.2 should cover the direct effects and any indirect, secondary, cumulative, transboundary, short-term, medium-term, and long-term, permanent and temporary, positive and negative effects of the development. So they're trying to be as exhaustive as possible there. Next slide, please. An assessment of the likely significant effects extends to the effects of the use of the works in question, as well as their mere construction. So you can't just stop at the stage when you've said, well, we've constructed it, the effects of that construction are enough. You actually then need to go on to look at the use. And there have been a number of examples of this applying in the case law. The first is Commission in Spain. That was a project to expand a railway by constructing additional track. And that needed to be subject to an environmental impact assessment, because the use of the expanded railway was likely to cause significant noise. So it was not just the construction of the railway itself, but also the use of the expanded railway once that it was constructed. Turning to the case of Abraham against Wallonia, this was a case where the assessment for the expansion of an airport by works to improve its existing infrastructure, including the widening of runways, which would enable it to be used more intensely, had to assess not only the impacts of the expansion itself, i.e. the works that needed to be carried out, but also of the increased activity that would result from it at the airport. And then Ecologistus, this is where the impacts of the use of an urban ring road, once improved, had to be assessed. So not merely the construction of the impacts of not merely the impacts of the construction works themselves, but what was going to happen on the road once built. And then lastly, the case of Preston. This is where the assessment for a proposed temporary discharge pipe for a wastewater treatment plant had to not only include the effects of the installation of the pipe, but also those of its discharge into a river. Next slide, please. So the question is, what are the indirect effects of a development? And it's an easier question to ask than answer often. And the existence and nature of indirect, secondary, or cumulative effects will, as the court has told us, always depend on the particular facts and circumstances of the development under consideration. And taking, for example, the case of Brown, this is where the environmental statement for the development of a freight distribution centre at an airport did not include, as it should have done, an assessment of the effects of the associated improvements to the airport itself, which were part of the same project, but were subject to a separate application for planning permission. Next slide, please. So it's fairly obvious, really, to say that if you are in a position where you need to assess a particular indirect effect, then that assessment needs to be adequate as a matter of law. And a good example of this principle being applied is that of Squire. This is where the environmental impact assessment for an intensive poultry rearing development was defective because it failed to properly consider the impact of odour and dust produced by poultry manure spread on surrounding farmland. So there was an identification that this was a clear and obvious indirect effect that had not been taken into account and assessed in the EIA. Next slide. This is so this really just leads us to the case of Finch itself, which was handed down on the 17th of February earlier this year. It concerns the judicial review of the grant of planning permission for 4 new oil wells on a site in Surrey to produce hydrocarbons over a period of 25 years. The basic question in the appeal, as Sir Keith Lindblom, the senior president of tribunals, identified at the outset of the judgment, is whether it was unlawful for a planning authority not to require the environmental impact assessment for a project of crude oil extraction for commercial purposes to include an assessment of the impacts of greenhouse gas emissions resulting from the eventual use of the refined products of that oil as fuel. Next slide. The judicial review application first came before Mr. Justice Holgate in December 2020. He dismissed the claim, concluding that downstream emissions could not, as a matter of law, be an effect of the development for the purposes of EIA, as Paul alluded to earlier. Next slide. When the decision was appealed to the Court of Appeal earlier this year in February disagreed with Mr. Justice Holgate, finding that it was not possible to say that such impacts, i.e. the downstream impacts arising from the combustion of the oil that's been produced, are legally incapable of being an effect requiring assessment in an EIA. Instead, what all 3 judges of the Court of Appeal agreed was that the question of whether any particular impact, including the impact in this case, is truly a likely significant effect of the proposed development, whether that's direct or indirect, is ultimately a matter of fact and evaluative judgment for the authority. Next slide. So how do you go about exercising that judgment? Well, the court said that in determining the direct or indirect effects of any particular development, what you're looking for is the necessary degree of connection that is required between the development and its putative effects. That's what you're looking at. Next slide. So looking at this legal framework applied to the particular facts in Finch, the court found that the relevant project in this case is the construction and the use of a working well site for the commercial extraction of crude oil for onward transport to refineries. So that's the project itself. Then when you start to look at the effects, it's a matter of fact and evaluative judgment for the authority to determine whether the impacts arising from the greenhouse gas emissions arising from the eventual use of the refined products of that oil amounts to an indirect effect of the project. The Court of Appeal went on to then, having agreed as to that legal framework, they went on to look at the County Council's reasoning in this particular case. The majority of the Court of Appeals, so 2 of the 3 judges, found that the County Council's reasons for not requiring the EIA to assess end-use greenhouse gas emissions was lawful. The senior president said that there's no need for an elaborate explanation. There was common ground. There was no duty on the authority to give reasons for a decision on the adequacy of an EIA. And taking a straightforward approach, the senior president said that the county council had provided terse but legally adequate reasons, and Lord Justice Lewison concluded, and quotes, "not without hesitation, that the reasons just about passed muster." Lord Justice Moylan, while not disagreeing with the majority on the points of law, he concluded that the assessment of the adequacy of the reasons given by the council were legally flawed. Next slide. As Paul referred to, there is an extant application made by Ms. Finch for permission to appeal to the Supreme Court. Submissions have been made in support by Friends of the Earth. The application is resisted by the Secretary of State, the County Council, and also Horse Hill Developments. It's worth saying that that application obviously went in only a couple of months ago. Certainly other cases that I have got that have been up at the Supreme Court recently have seen permission decisions generally taking up to and even longer than a year to be determined. So there may be some waiting involved in finding out what the last word is on Finch and this whole area. But in the meantime, if we just go to the next slide, this is the Greenpeace case, which was decided between Finch in the High Court and Finch in the Court of Appeal. It's referred to in the Court of Appeal's judgment in Finch. It's a case from Scotland where the court had to consider whether the EIA for the operation of 2 North Sea oil wells ought to have included an assessment of the impacts of the later consumption of the extracted and refined oil. The court concluded, similar to Finch in the High Court, that the ultimate consumption of oil and gas, once they had been extracted from the wells and then transported, refined, and sold onto and used by consumers, did not give rise to direct or indirect significant effects of the relevant project. In the court's view, the ultimate use of a finished product was not a direct or indirect effect of the project, and it was that effect alone which, in the terms of the regulations, must be assessed. The court went on to say that however broad and purposive an interpretation of the regulations or the directive might be attempted, the clearly expressed wording of the legislation cannot be disregarded. It is the effect of the project and its operation that is to be considered, and not that of the consumption of any retailed product ultimately emerging as a result of the refinement of the raw material. I'm quoting the court there. And then further from the court, the parameters of what is to be assessed are defined by reference to the effects of the project. Just as an aside, the court also observed that the argument was in that case academic because it had not been maintained that the exploitation of this particular oil field would increase or even maintain the current level of consumption of oil and gas. It's worth noting that this case is also the subject of an extant application for permission to appeal in the Supreme Court. Next slide. Next up is a case from the Irish Supreme Court. This is a case all about a cheese factory, and for those involved in the world of dairy, or who like cheese indeed, you will know that in order to make cheese, you need milk, and an enormous amount of it. This particular factory was projected to consume 450 million litres of milk every year, which amounts to 4.5% of the total Irish milk supply by 2025. So the interesting angle that's presented by this case is that whereas the Finch and the Greenpeace case were all about whether indirect downstream impacts need to be taken into account in an EIA, this case is all about indirect upstream impacts. So the impacts that arise from the milk supply chain to the factories. So obviously all of that milk needs to be produced from Irish dairy farms. And the EIA in this particular case did not assess the upstream impacts arising from that production of milk for the purposes of supplying the cheese factory. Planning permission was granted. The Irish National Trust, which I think is pronounced Antoshka, challenged the decision. The Irish Supreme Court identified 2 potential interpretations of the relevant legislation. Either indirect effects were to be understood in an open-ended fashion, or restricted to those which the development itself has on the environment. The court essentially found that the open-ended interpretation was too remote and impractical, and the court, in the words of the court, it would leave hardly any limits but the sky. So they were clearly relying on some of the arguments that Paul referred to earlier about how practical is it to be assessing these. So for my final slide, I've just identified a few of what I see to be the main key questions that arise from all of this litigation, and the questions that will hopefully to some extent be answered by further litigation if that is brought. And that is, firstly, can it really be right to leave it to the judgment of an authority in individual decisions whether an effect is an effect which has to be assessed? Does that generate too much uncertainty and inconsistency and mean that relevant effects might be included in the assessment of one authority but then not included in the assessment of another project, even if those projects are very similar? Could there ever be an obligation as a matter of law to require a particular effect to be assessed, or is it always just a judgment call for the authority? So in other words, when can the exclusion of a potential indirect effect be a patent defect in an EIA that could lead it to be quashed as unlawful? Thirdly, what is the relevance of intermediate processes between a project and the effects, such as the process of refining oil in Finch? Do these intervening processes mean that it's more difficult to say that an effect is an indirect effect of the development? Fourthly, what is the relevance of the practicability of assessment, one of the factors that Paul was referring to earlier? Fifth, is it always possible to distinguish a project from its effects? It always, logically, you firstly identify the project, then you think about the effects of the project, but sometimes that fine distinction can be blurred. Sixth, the really important question that Paul referred to earlier about how does the judgment on indirect effects for the purposes of EIA interact with the wider question as a matter of planning law of what is a material planning consideration? And then finally, if the downstream effects had been assessed, for example, in Finch or in any other case, what impact would that have on the decision whether to grant planning permission? And one might say, if one was advising a particular applicant for planning permission, that if it's unlikely to change the outcome, then why not just assess the effects on a precautionary basis? So those are the questions that I think are the most interesting generated from this litigation. Thank you very much for listening, and I'll now hand over to Nick.
Thank you, Matt, and to everyone who's attending today. So I'm going to look at some of the practical implications as Paul referred to, and to what extent can you define or confine a project? So there's a line beyond which you can say that indirect effects are not causally connected to it and do not therefore need to be considered in the ES. Next slide, please. Can you erect a fence of some sort against which your effects are drawn, and is it a close bordered one or rather more like the open one shown on the slide? Next slide, please. So some projects will appropriately need to be screened to consider whether an ES is required, and in relation to that process, it's important to consider the full range of potential effects arising from the project to ensure the screening opinion is robust. But most projects, and the ones certainly we're concerned with in principle today, are those that will proceed straight to scoping, as occurred in Finch, and where there was a change in position between the scoping opinion, where the Mineral Planning Authority said that the assessment of downstream GHG emissions was required, and then the ES and the determination of the application where the MPA accepted this was not necessary. This illustrates one initial point, which is that the scoping opinion is clearly very important, and the requirement is the ES must be based on it, but the opinion does not need necessarily to be slavishly followed. Any departure from it is, of course, going to attract attention and will need to be discussed with the relevant planning authority and perhaps statutory consultees as well. But there are opportunities to move on from a position set in the scoping opinion. Clearly, if a promoter does not assess an effect set in the scoping opinion to be relevant, that would need to be justified. And there's always the potential for the local planning authority to continue to disagree and to require the provision of further information. That would cause cost and delay. The scheme definition in the scoping report is necessarily at a relatively early stage, and the scheme's design, layout, etc. will clearly not be known, but its purpose, objectives, and from those, the definitions of the scheme start to flow will be. And Finch, it was obvious that the oil would be transported, refined and sold for use as fuel. And equally, this position will be the same for the requirement for a supply of milk for its cheese factory or the existence of those living in a housing development. It's of course not possible to alter a project's underlying purpose, the extraction of oil for commercial purposes or residential use of houses, but the scoping report is the first formal opportunity for the developer to set out whether and to what extent there is a causal connection between the project and potential indirect effects. And equally, the scoping opinion is the local planning authority's first formal occasion on which to do the same. The final point in relation to scoping is that there's potentially a tension between wanting to limit the project and the effects to be considered, that's what the promoter is seeking to do, and wanting to obtain a robust scoping opinion. That's not a new point that arises from Finch as such, but the case does serve to potentially increase the range of effects that need to be considered and dealt with. Next slide, please. I don't intend to dwell on this slide, but it is relevant to note the court acknowledged the possibility of activities occurring which are not in any consenting context considered in an EIA. That would, on the basis of what happened in Finch, be the case for the use, the combustion of the fuels in vehicles derived originally from the well site in Surrey. There's no requirement under the EIA regulations to ensure that all potential effects are or will be addressed in an ES at some point. The EIA regime, the court said, fits within the wider planning regime to inform decisions made under the latter and isn't intended to regulate environmental effects of economic and other general activity. Next slide, please. So with a clear idea of the principle laid down in Finch, what does a project promoter and its team then need to consider and address? And equally, what does the local planning authority need to consider? Where there's a consistent position through the scoping report, scoping opinion, then yes, the position is clearly simpler. And assuming the relevant effect has been, if this is a case, robustly scoped out, then, and there's not been a relevant change in the project scope or definition, then the ES may not itself need to deal with that particular issue. Where the promoter is considering potential indirect effects and which may need to be considered in the ES, they now need to do so with a view to ensuring that the local planning authority has robust information on which to make the judgment. Being clear about what the project is and does include, and the opposite, will be an important part of setting up a robust approach to the whole EIA. Finch concerned indirect GHG emissions arising downstream, but the potential reach of indirect effects, as Matt noted, is clearly not limited to that and could include those upstream as well. So how might upstream or downstream effects be relevant in other contexts? If a promoter is applying for, say, a new garden village and proposes 5,000 homes, all of the same size and style, that's just to make my maths easier, quite apart from the major design issues they will no doubt encounter, they may need around 50 million bricks by the end of the project. It's not uncommon for a socioeconomic chapter of an ES to count jobs created directly by a project and those induced in the wider economy, for instance, through the supply chain. Could there be any potential adverse effects arising from that supply chain required to supply those many bricks? The GHG assessment may consider embodied carbon. What about any other topics? Could there be a requirement for mining activity, new factories or other facilities, which could themselves have effects? Similarly, once built, those houses will have occupiers and who will have a range of needs that must be met. The ES will likely consider those in relevant topic chapters, such as the need for a new doctor's surgery and whether that is to be provided or paid for. What about other less commonly required health services within hospitals, or knock-on effects on the existing community of service will be, notwithstanding any mitigation, increasingly used? Similar concepts can, of course, be considered for any nature of development proposal. For an electricity generation scheme, you may have to consider where the fuel supply comes from, and there could be factors which are relevant to consider, such as whether the fuel is derived from a specific place or source, or whether it's from a common regulated supply, for instance. Some of those examples are pretty indirect in terms of a link with a project, and I certainly wouldn't recommend using my brick maths for procuring your raw materials, but they do serve to demonstrate that for any particular topic or aspect of a project, it's possible to describe a long chain of effects potentially, and which become increasingly distant from the project, which is the subject of the application. It's worth noting at this stage that those indirect effects may be inevitable, such as the combustion of the fuel derived from the proposed oil wells in Finch, but that's not the relevant test as to whether they must be considered in the ES. As the court made clear, the inevitability of the indirect effects may well go to whether they are effects of the proposed development, but doesn't compel an answer that they are. So the use of a range of treatments provided in a hospital by new residents may be possible, or even greater may be likely, but that does not mean that that must be an indirect effect of that development necessarily. So the promoter's job is to help the local planning authority to draw the line with reasons along that chain of effects at an appropriate place to identify those effects that are within the fence and must be assessed, and those that are not. It's worth noting the promoter does have a degree of choice about how it proceeds. It could decide that a balance of risk lies in providing an assessment of an indirect effect, and more widely making the case that consent should be granted notwithstanding that effect, assuming it's an adverse one. And that goes to Matt's big question number 7. Secondly, is that from the local planning authority's perspective, the appropriate scope of an ES may of course be influenced by politics and what it would want to see assessed. That ever-present facet of consenting is no less relevant in relation to how matters proceed in relation to a particular application. And lastly, there may be planning policies which bear on the assessments that have to be provided as part of the overall package. Just by way of example, the London Plan requires a whole life carbon assessment, applies to developments which are referable to the London Mayor. And it's likely those will also be subject to EIA, but it illustrates the points that planning policies may exist, which mean that a certain type or level of assessment has to be provided regardless of what the EIA regulations require. Next slide, please. So in conclusion, promoters and all local planning authorities don't have the apparent clean line that the High Court in Finch held to exist, and they have to grapple with the complicated reality of a project sitting within a much broader context of other developments, existing facilities and processes. A promoter does have opportunities through the scoping and determination process to provide the local planning authority with the information it needs to consider the indirect effects and to decide rationally and robustly which should or should not be assessed. And that starts with clearly defining the project itself. Thank you. I will now pass over to Stephanie.
Thank you, Nick. Good morning, everyone. I'm Stephanie Baldwin. I'll just have a discuss the indirect downstream emissions matter from a practitioner perspective. First slide, please. As an EIA practitioner, this issue raises a lot of questions, and there is GHG guidance out there to help us with our assessments. I think further guidance would be useful for ourselves and for the decision makers. It made me think, could there be more guidance on which types of projects need to be considered for this? The other speakers have been through various aspects like that, but is it just fossil fuels? Are there other projects that might generate emissions that we end up having to assess? Thresholds, exemptions, could it be a case that some smaller projects don't need to be assessed? That would help decision makers as well. Or is it just on a case-by-case basis, depending on the level of emissions or downstream effects that may be realized by a project? Project boundaries, which we've been through. But again, I think for decision makers, for planning authorities to understand what type of project boundaries that the indirect effects question presents would be useful, because it's, it could be quite a lot of interpretation depending on how you view the actual project itself and any associated activities or processes. The other aspect I was thinking it would be useful for us to have some additional guidance on is what constitutes significant. That's a very big question in EIA, obviously. So where does that where does that come in? It will vary from project to project depending on what assessments, but there should be something in our scoping in our EIA method or approach that we're discussing with decision makers what is going to constitute significant, and that could be a debate in itself, really. So on that basis, I think that in every project, it's critical for us in terms of when we're scoping and we're describing what our EIA approach or method is going to be, that the scope, the context, the assumptions are clearly stated. I think that when we're talking with the planning authorities about what our intention is in terms of the assessment and the parameters for the assessment, we're going to have to be particularly clear in how it's being mapped out and what assumptions are being used and what it might mean for the assessment and the outcomes of the assessment. So that the plea application discussions with planning authorities will be critical from a technical perspective, but there may also be the discussions about whether or not some aspects of the assessment should be considered just on the basis of risk of challenge or objection. I mean, that's just a call that we will have to make. That it may be something on the planning authorities' minds as well. So while some other parts of our assessments are quite well established, there are standards, historical experience, practice experience with this question of indirect effects, how far it goes, what does it involve. We probably will need to have a little bit more time in our schedule for discussing and agreeing the scope of this with the planning authorities. This was my feeling. So in order for us to map out what the indirect effects or emissions could be associated with a project, and the obvious place to start, as we discussed already, is mapping out, doing analysis of the on-site upstream, downstream emissions from the project. I think also doing a life cycle analysis of the proposal, of the development, to try and, again, visually map out all the different parts of this, something that could be construed as indirect effects would be useful. it then also might be useful to take those pieces and look at them from a different lens of maybe what's already consented, what might already be subject to carbon or emission reduction strategies. How does that play into our assessment? Is it an indirect effect? Does it then become something we consider as cumulative assessments? The assessment methods themselves, when we're doing scoping and again, we're mapping out our approach, we need to use best available science and the current data. Now that presents another complication because these issues and the different activities, different processes that might be involved, as the other speakers have laid out, are very complex. And I think that you could easily be in a position where we present an assessment in a particular way based on particular data sets, modeling, etc. And there is every possibility that challengers, objectors, other parties may say, well, actually, we think this data is more appropriate. And that's because this is such an emerging field and its scope is so vast, potentially global. It's something that will be called into question. So I think from an assessment perspective, maybe there's a point where we have to do a little bit of sensitivity testing to see what if we did use different data or we did consider different impacts, while we're going through the process, just to see whether that would change our outcomes. It's also, again, technically complicated with the indirect effects question when we're defining aspects like our baseline versus our development scenario in terms of GHG carbon emissions. What do they construe, the timelines involved, year 1 versus year 30. We'll have to consider all of those aspects when we're working out what the best approach for assessment is. And it also made me wonder how the indirect effects question might call into the sort of shaping of your assessment method, how you deal with alternatives. So what role will they play, with this lens on them? So again, there is no standard guidance, consistent approach for this yet. So we really will just have to work it out on a project by project basis. We'll have to map everything out and we have to see where it takes us and think about what is meaningful, how we can use the data that we have to do an assessment, and and does it all make sense, and then again view it again from a risk, the risk of being challenged on any of those points of our assessment. Next slide, please. So where we identify impacts or effects, there needs to be mitigation. So again, this is another interesting question for us, for practitioners and for decision makers in terms of what is sufficient mitigation to deal with indirect effects. What elements would form a mitigation plan? Would just be the actual project itself. We're looking at, as discussed previously, extraction, transportation. What does that mean for the assessment and the developer, the proponent? Because some of those elements, probably quite a few, are not within their control. So how are these being dealt with? How should these be dealt with? Decarbonization strategies. I think this would be an interesting point. So how much should decarbonization strategies be taken into account by these projects? Again, if it's something that's within the proponent's control, it's probably quite doable. How much weight do we give to commitments by other parties that are in the process chain for decarbonization? How do the decision makers weigh that up in terms of being effective mitigation, if you like? And then further on through the process, what reporting, performing, monitoring, would need to be committed to demonstrate these goals. So again, you're showing that you are actually delivering what you promised. And just to finish up, mindful of the time and questions, I thought that this actually, less as a practitioner, but just as an observation, does this represent an opportunity? Does this shift in thinking represent an opportunity for projects, performance developers to maybe think a little bit more about alternatives and what is needed to transition to net zero? Is it going to kind of help support some of that, transition work that needs to happen? So I just thought I would end on a positive note, saying that, yeah, I think that there is an opportunity here as well. So I will leave it there as time is passing. Thank you very much.
Thank you very much, Stephanie. Well, that brings us to questions. Good. So just taking some of the points that have come up on the Q&A already. There's a comment that came in from Katie Dekawa in relation to what exactly it was that the Finch litigation decided. I'm not sure that it's a question as such, but it does point out that I think it picks up on the fact that Matt has suggested there was agreement on certain points of principle about what the project was, and the question is, or the suggestion is that may not actually be entirely right, given the dissenting judgment of Lord Justice Moylan, where, and there's a quotation from it, key nature of development is the extraction of oil for commercial purposes. That is the project. I'm not going to ask, well, I don't know, Matt might want to venture a view on it, or he might think it's probably inappropriate too, since this is ongoing litigation. But,
I'm happy to deal with the question. It's a very good question, Katie, and I don't think I'm trespassing on anything that I shouldn't be saying. I think it is right that Lord Justice Moylan doesn't agree with everything that his two colleagues have said. Otherwise, he wouldn't be dissenting. I think what I meant by them agreeing on the main point of principle is the point that I articulated in my talk about how it's always a question of judgment for the decision maker. It's not a hard-edged question of law one way or the other. Either these must be assessed or they're legally incapable of being assessed, which is the arguments that were being advanced on different sides. And that's made clear by Lord Justice Moylan in the paragraph after, paragraph 129. You're absolutely right that there is definitely a disagreement as to what the outcome of the particular project in this case is. Lord Justice Lindblom thought it was focused on the site itself and what was going on the site, and Lord Justice Moylan thought that the outcome was the actual commercial end use of the oil. That's the outcome. So there's a difference there, but I think it's more a difference in the application of principles. And I think we also need to bear in mind what Lord Justice Lindblom said earlier, which is that the outcome is sort of his word for end product, which is a word which, or a phrase which was bandied around a lot in the proceedings. What is the end product of the development? And I think what Lord Justice Lindblom said was that actually this is a term of art. It's not a term that's found in the legislation. And I think if you read his judgment as a whole, you can see that he's saying you need to focus on the words in the legislation themselves and think about, firstly, what is the project, what are the effects, and not get too hung up on phrases such as what is the end product or indeed what is the outcome. That's what I would say in response.
I think the paragraph that Katie quotes actually is quite a good illustration of what is still, I think, an unclear line. On one hand, the Court of Appeal unanimously saying this is a matter of judgment for the decision maker, but then you read paragraph 128 of Lord Justice Moylan, and that is Lord Justice Moylan telling us what he thinks is the case. And that's something that you can see through a lot of the authorities, and it goes back to the point that I made about Bowen and Lord Justice Law's observation there, that this is an area where the courts have been quite energetic to make sure that that people don't sidestep the legislation. Okay, I've got a couple of questions about a suggestion that I made in my first presentation about the extent to which it might just be easier sometimes for developers to volunteer information. And one of those comes from Victoria Barnes, who's asked whether or not there's a danger about setting a precedent there, particularly if it means signing up to assessing things that are increasingly remote. Do you make a rod for your own back? I'd relate this to one of the questions that Matt asked, which is it actually desirable that this is a matter of judgment to be made by the local authority on the particular facts of the case? Because that way, it seems to me, is a road to inconsistency in planning, which is one of the things that should not happen. You will get different authorities reaching different conclusions on what are, to all intents and purposes, identical schemes. And in each case, a court will come along and say, well, that was a reasonable conclusion. And I mean, I don't know, but it seems to me, for the purposes of providing advice, it's not particularly helpful to anybody out there to say, well, you're not going to know until you've asked the council the question and brought in some help from Stephanie to try and persuade them as to what the answer should be. But does anyone else on the panel have views about that? No? No. There was a second question still about doing things voluntarily from Peter Walden, which was, if you look at the way in which environmental information is put forward in a statement, there's a fairly well-trodden path for doing it, assessment, mitigation, residual effects. Would you need to do that for material that's put in voluntarily? My own answer to that would be, if you are doing it in order to plug a potential legal challenge further down the road, then logically you would follow the same structure, because one of the reasons why environmental statements do that is because there are pretty clear requirements as to what should be in an environmental statement. And if your objective is to effectively have it there in the background in any event, you'd want to make sure you've covered all the bases. It does get more difficult when this happens at the appeal level. So the initial environmental statement doesn't include the information, and it then seeps into an inquiry, for example, in proofs of evidence. And I think in those circumstances, the information is less likely to be presented in that clear-cut way, but may still get you over the line. But I think my starting point would be, there's a reason why you write environmental statements that way, and if you're going to offer something voluntarily, logically you do the same thing. I see general nods from.
I suppose I would suggest an environmental statement went about dealing with an issue like this is if you don't think that an effect is a direct or an indirect effect of the development. For example, I think it's similar to the end use effects that arose in Finch, is to have a section on such effects, i.e. these are effects that we don't consider to be effects of the development. However, in the event that the local authority disagree with our analysis, here's an assessment of the effects offered on a precautionary basis. I mean, that's certainly how I would be suggesting, and that way you're not implicitly accepting that they are effects, but you're just making sure that if the authority does disagree with you, and they may well, because it's a question of judgment, that you've got those effects there, assessed, ready to go, so you're not having to scramble for it at a later stage in the way that Paul suggests, for example, on an appeal.
Yeah. Again, you can sometimes use sensitivity testing for that kind of what if scenarios. They do tend to be presented a little bit differently because you don't want to cloud the separation between your actual formal assessment and something that maybe hasn't been through an equally robust level of assessment, if that makes sense. So again, you sort of make the call as depending on the situation of the project. Yeah.
I think an interesting question that hasn't emerged yet, but it comes up in this context, is how does this fit with screening? So obviously the EIA does have an initial screening stage. So what do you do about effects which you don't consider to be effects of the project? Do you screen them out? Because if you screen them out, then obviously you're not going to look at them in your environmental statement. And I think
again, on a precautionary basis, you would be arguing effectively not to screen them out, but then make it very clear in the environmental statement when you do come to consider the impacts, you don't consider them to be effects of the development.
And then just in terms of topics overall, there are two questions. Crystal ball gazing, but we know, or we're told at the moment, that we've got a new bill, the LURB, with proposals which will affect the way in which we go about environmentally assessing things, environmental outcome reports. And the question's been asked, well, what's the consequence of that going to be? Is it going to make things simpler? Will these issues go away? Will it make them easier to manage legally? Slightly difficult until we know exactly what the legislation is going to say, but we have a pretty clear indication of the direction of travel at the moment. Does anybody want to venture a view? Nick?
Yeah, thanks, Paul. So yeah, we do know from what the government issued alongside the bill that the EORs would replace, sorry, someone had to say it, would replace EIA and SEA, and projects would be assessed against tangible outcomes set by government. But we don't know how general or specific those would be, how often they might change, and we also don't know for any particular topic what they would actually be. So for climate change, might the outcome be the achievement of net zero by 2050, or an interim carbon budget, or something more specific in relation to a particular development's contribution to a sector's emissions targets? We don't know. And so at the moment, it's certainly got the potential to significantly change what the environmental assessment that accompanies an application has to do, but there's a lot still to be confirmed by government and worked up over the coming years.
It seems to me a lot of the proposals are driven by a frustration, which I think many people in practice sort of share. That environmental statements have got to a point now where they go well beyond their intended use, which was to inform decisions. And the reason why is not because the information's not there, but just because there is so much of it. It's presented in so many volumes and so many appendices with so many technical reports supporting it that it's almost indigestible. It's why you need a non-technical summary, but even the non-technical summaries sometimes are quite complicated. I can understand a desire to cut through that to a simpler form of information, but I'm not clear in my own mind how that's going to affect the basic decision, what is the information that you need to be provided. It seems to me that is always going to be a central question. But it does take us to, I think, the last question we've just got time for, which relates to, we've been talking a lot about climate change. It's quite relatively easy to look at greenhouse gas emissions, about what happens when you burn coal or oil or gas. But if you read the judgment of Mr. Justice Holgate at first instance, he does, in the first few paragraphs, spend quite a lot of time relating this to how far do you take this? For example, if you're looking at an application for forestry, how many different wood products at the end of the day are there going to be? If you're looking at a new steel works, are you talking about steel that's going to be used in making wind farms or making gas guzzling cars? How do you go about, if you accept that indirect effects can have the wider sort of meaning that was argued for by the claimants in Finch, what then do you consider to be the indirects that have to be taken into account in other cases? I'm going to pass that one back to Matt because he's smiling at me.
Really kind of marvel at the interconnectedness of the world we live in, and how everything that we do. And this comes back to the Greenpeace case, the Irish Supreme Court case I was referring to, which is we can't just look in one direction, which is downstream impacts, but also upstream, all the things that have to happen to something before it can actually get to the project in question in a particular application of planning permission. So I thought that, Nick, I think it was your slide, which had that pictorial representation of the different stages of a development was quite remarkable, because if you pinpoint one particular stage in a process, in and you need to look both backwards and forwards at all the different possible parts of that. And I mean, it could be quite an extraordinary operation to just try and track every conceivable effect from the moment you take something out of the ground to the moment it goes back in the ground at the end of the day. So it's really hard. And I think, just going back to the question about the environmental outcome reports, I think although we don't know much at this stage about what the government's proposing, it does seem to me to be quite a big opportunity for the government to set out what they want, what they think should be done about how to go about assessing the direct effects.
Yeah. And indeed, it might in some ways be easier if we had some clear rules. We might not like them, but we'd know what they were, and it'd be easier to work within that. Well, ladies and gentlemen, I think that brings us to the end of this, where we're slightly over time because we started late. I'd like to thank all of the speakers. I would also like to thank you not only for joining us, but also for bearing with us through the technical difficulties. It's quite clear from the chats that there's a degree of frustration about that, and believe me, that's shared and understood. But the technical team here have been working constantly in the background trying to fix it. Sadly, these things happen, and we'll do our best to make sure it doesn't happen next time around. But I'm very grateful to you for bearing with us. I hope that notwithstanding those difficulties, you still found today useful and interesting. And thank you very much for participating. As I indicated at the outset, the presentations will be available at the end of this, and I think there'll be a link sent to you as soon as we can sort that out. Thank you very much indeed. Goodbye.